I'm ready. Don't I look ready? I've got, look at this. I've got a ton of stuff in my pocket. I'm all clipped up here. And I got my coat and tie, so I guess I'm good to go. So, good morning. My name is Henry Schlein. I'm a lawyer in Somerville. I'm a retired policeman with the Charleston Police Department. And this year, 2017, I figured I'm retired 21 years, which is as much time as I had on the force. So next year, I've got more time retired than I have on the job. So this is a milestone. But good morning. I'm glad you all came. This is one of my favorite times of the year. Well, let's see, going to a gun show or going to the gun seminar. I don't know. It's a toss. Well, okay. Maybe this is more fun. But everybody got a book like this, and in there there's a couple of sections, two different sections that say, what does it say? Domestic violence charges and gun rights. None of my materials is in this book, so don't waste your time looking for that. Instead, go find the outline that Steve's mom gave you out there that says these materials were not in the book, and it's this. So there was a handout that looked like this, and then maybe another piece of paper, and that piece of paper had it said page 7.5 on the bottom. That was because it went with this TV thing is in the way. I'm sorry. It went with this outline, and on this outline there's pages are numbered, and you find page 7. It went between 7 and 8, but actually it should go between page 6 and 7. But it doesn't matter as long as you get it in there. It was after I wrote up the outline, I remembered I didn't talk about permanent restraining orders, the new thing, so I wanted to give you something on that. I'm very sorry it's not in the book, but I did want you to have the material. So, first off, I want to talk a little bit about why do we need to know about domestic violence and firearms, because if you're a judge or a lawyer, you know that in South Carolina, folks value their hunting rights and their rights to firearms. Not everybody hunts and fishes. A lot of people do. A lot of people just like guns. But in South Carolina, people just like them. They're very big. They've probably got more guns than we do people. So if you're one of those folks, fine. If you're not, that's your deal. But if you're going to be representing people or adjudicating people in South Carolina, you know that's a big consideration for a lot of folks. I've got a client right now who's never owned a gun, but he won a gun, and because he's got some possible domestic violence impediment in his history, he's not allowed to go pick that up. So we're trying to work on that. I don't want to get into too much detail because it's still active, but here's somebody who never had one, never thought about one, but now that he found out that he's got a problem buying it for legal reasons, now it's a problem. So, the Bill of Rights is basically your civil rights. The Second Amendment, that's 1/10 of your civil rights. So it's a pretty big deal all the way around. Okay, everybody knows that a convicted felon is prohibited from owning or possessing firearms or ammunition, in layman's terms. But if you're convicted of a misdemeanor crime of domestic violence, even though it's a misdemeanor, you're also prohibited from owning or possessing firearms or ammunition. You cannot take your kid hunting. You cannot teach your child to shoot. You can't even you're not even a person who's allowed to authorize someone else to do it if you're not allowed to do it. So it's a big prohibition there. In 2015, the General Assembly revised our domestic violence code. One thing was we stopped calling it criminal domestic violence, CDV. It's now just called domestic violence. And I think they were trying to make a point that, if it's domestic violence, it is a crime. We don't need to, there is not non-criminal domestic violence and criminal domestic. And they just wanted to make a point that you know, if it's domestic violence, it is criminal if it rises to that level. So that's one reason for the change in the name. Another big change was up until 2015, the end of 2015, with the revised code, there was only a federal law that prohibited people from convicted of the misdemeanor crime of domestic violence from owning or possessing firearms or ammunition. There was a lot of contention in the General Assembly and in the general public in South Carolina about whether South Carolina needed to have that law, because you know, there's a lot of, I don't want to say maybe old school thinking, but there was a lot of thinking that people who, you know, some people believe that if you're a convicted felon, you shouldn't lose your right to defend yourself. I was on a road trip when I was in law school. I took, you know, I got something I hadn't had in over 20 years, 25 years. I got summers off. I said, wow, I'm a student now. I get the summer off. Wow, I think I'll go travel. So I went on a road trip, and I was in Arizona, and I stopped to talk to somebody who posed that to me. He says, well, why, as a convicted, don't worry about how we got to talking. But, we were talking, and he said, if you're a convicted felon, why should you lose your right to defend yourself? And I really hadn't thought about that. I came from a law enforcement background, and you know, 1968 Gun Control Act was with us for a long time, and I kind of grew up with that. So again, me not making a judgment about it, form your own opinions, but I hadn't thought of it that way. And then I realized some people, you know, do think that. They wonder that. So South Carolina was, you know, we didn't know whether we wanted a state law, but we did have the federal law. So even if we didn't have a state law, it was always illegal under federal law. If you have a conviction for domestic violence, you cannot own or possess firearms or ammunition. But now we have a state law. Now, the state code sort of follows the federal code, but it kind of carves out, it's a little different. So even if there's a gap in the state code, the federal code still prohibits that. I think I cited the sections in the outline, so we don't need to go into great detail, but one of the interesting points in the South Carolina code is, and this reflects the controversy, South Carolina says if you've been convicted of a violation of domestic violence first degree, which is the 10-year felony version, domestic violence high and aggravated, which is the 20-year felony version, or a similar crime in another state or tribe or territory, or second degree, the misdemeanor version. And in that case, the court made specific findings and concluded that the person caused moderate bodily injury to their household member. You know, you got to have that, the court has to make those findings. Then the state code applies. Or third degree, which is a 90-day misdemeanor now, no longer 30. And not only did the judge make those findings, but he made findings that you are prohibited from shipping, transporting, receiving, or possessing a firearm or ammunition. Then it applies the same way that the federal law applies. So this language in there tells you that there was controversy, and I remember reading about it. Some people didn't want to have it, and finally they compromised, and we got this bill. But notwithstanding any of that, by law, federal or state, if you're convicted of domestic violence, you cannot own or possess firearms or ammunition. So you need to know that. What about while the charge is pending? You know, everybody's innocent until they're proven guilty. Anybody who's ever gone up for a bond hearing, you know, sometimes, I know we have some judges here, but sometimes if you're a defense attorney, you feel like the magistrate is almost pronouncing a sentence on the defendant when they set bond, with some of the high bonds that they set. Go figure. So, sometimes it's appropriate. Sometimes you as a defense attorney might feel like the judge is punishing the defendant who's innocent. I always, when we do these bond motions for bond reduction, you go to the circuit court. Usually the circuit court will give you some consideration, but there's one judge who, primarily in Charleston and Berkeley, and I'm going to call his name, it's Judge Markley Dennis. He will always say, innocent until proven guilty. He makes a point of saying that, the defendant's innocent until proven guilty. Then he's going to set some kind of a bond on you. He's going to give you something. But he acknowledges that, and I had another circuit court judge acknowledge that same point. I said, you know what? They must have had lunch. Because, we got to remember that. But, okay, while somebody's getting a bond hearing for domestic violence, it's perfectly within the purview of the magistrate to set conditions, terms and conditions of release. They can order ankle monitoring. There's a lot of things they could do. And one of them is they could say, well, person charged with domestic violence, depending on what they hear, they can make a determination that person can't own or possess firearms or ammunition while they're out on bond. Of course, we know that if you get indicted for a felony or something, that carries those prohibitions, you're also a prohibited person. But I was in, I don't want to jump ahead too much, but I was in an order of protection hearing when I was doing those things that you have to do as a lawyer. I don't know, we call them 403s or whatever they are, where you have to witness so many trials and things, and before you can be allowed to practice, appear in court on your own. And I was watching a judge do an order of protection hearing, and the plaintiff, the petitioner, said, "But Judge, and I don't want to use genders here, that Judge, they have a lot of guns." And the judge said, "Turn them in. Go to the sheriff's office today and turn those guns in." Order the person to turn them in. I don't know what happened, but that judge ordered that to happen. So a magistrate could set as a condition of bond that you can't own or possess a firearm. So what does a person do if he's got, I don't know, guns, multiple guns, 150 guns? Find a friend to take custody of them, ask the lawyer to take them, maybe give them to you for a fee, I don't know. I have a friend who owns a gun shop, and I had a client go, I think one time I took a gun and turned it in for repair. I said, cleaning on it. And I said, I just put it in there. They didn't charge me anything. I just put it there. It was out of possession of the person. The person couldn't really access it because I'm the one that turned it in, so they wouldn't give it to that person. They'd only give it to me because I'm the one that signed it in, so they're not going to give it to someone else. So it was another time, I think I had the client go rent a locker at the gun shop, put it in the locker, and they're there. Just don't access the locker. It's not in your possession as long as you don't access it. So you may think about some ways you want to address that. Doesn't happen very often, but that's out there. All right, all of us lawyers, sometimes we know when we're whipped, and we say, you know what, if we go to trial, this isn't a very good triable case for me as a defense attorney or for you as a defendant. I don't think we can win this one. Maybe we should try to work out some kind of a plea bargain. Hey, we do that all the time, right? A common plea bargain for a person charged with domestic violence in municipal and magistrates court is what? Simple assault, assault third degree. We've taken those pleas before. Prosecutor comes up, or the police says, I'll let him plead guilty to simple assault. How about that? What's wrong with that picture? Anything? Well, maybe, maybe not. But if you're trying to avoid the federal firearms prohibition, You know, you might avoid the state one, but remember, not with the state one is just there. The federal one is a little more restrictive, and that's always going to be there. You can't really nullify it. I think the state makes an attempt, and you know, to maybe address it, but you can't nullify it. You know, we fought that battle 150 years ago. We're not going through that again. Back in 2009, the case came before the U.S. Supreme Court. U.S. versus Hayes is a Virginia case, and what happened was in Virginia, I think Mr. Hayes got arrested for something, came to the attention of law enforcement on something, and they found that he had firearms in his house. And well, it turns out Mr. Hayes had pled guilty or been convicted. I don't remember if it was a plea or conviction for something else, but he was convicted for battery, and it involved his wife. Well, does that amount to the misdemeanor crime of domestic violence that the federal statute specifies for purposes of the prohibition against firearms? And the Supreme Court said yes. That was a 7-2 decision, if I recall correctly, U.S. versus Hayes. So Justice Roberts, Chief Justice Roberts, dissented primarily because he was hanging on to the rule of lenity, that if it wasn't real clear, I mean, we're talking about a criminal conviction, we should be a little more lenient in the interpretation if it's not real clear. But the majority opinion, and by a clear majority, 7 justices, said that no, the underlying offense was the harm or threat of harm or the battery of an intimate partner, or you know, someone with whom he was intimate. You know, that language, paraphrasing the language. So therefore, since the underlying facts were what gave rise to the elements of the conviction, they felt like he committed the crime of misdemeanor battery. So no matter what you call it, if you want to call it simple assault, you want to call it third degree, or something else, if those were the underlying facts, and the government wants to make a case against you, and I mean the government, I mean, you know, it could be the federal government, or you know, the state, if you've got the state code going now, they can get you. Again, usually these people are not just people aren't just going up and saying, let's go knock on everybody's door who's been convicted of domestic, but like they do in California. See, if you've been convicted of something, we've got to check that you have any guns, you need to turn them into us. We haven't gone there yet. Some states do that. These people that come into the attention of law enforcement are something else, and that's where it's coming up. Well, these are add-on charges. More languages in there. Yes, sir, Robert.
You talked about plea bargaining down from a simple criminal domestic violence to a situation as assault and battery.
Yeah.
Assault and battery doesn't have a factual part of it. One of the requirements, one of the elements is not a relationship with the person who is the victim. In some instances, that's going to be clear. Husband and wife, there's a marriage, that's kind of hard to hide. In other instances, you may have a true question with boyfriend, girlfriend, where they really and truly in that relationship or not. Have you ever had a situation where you've asked or worked with the judge to find, as part of his findings, that there was not a relationship?
The question is, I'm going to try to shorten it down a little bit. If you have a client where it starts out with a domestic violence charge, and then you're trying to go to a misdemeanor charge of simple assault, and I'm going to say the suspect and the victim, although you know sometimes it's kind of blurry who's the suspect and who's the victim, but the parties are not married, and it's questionable whether there's a relationship. Have I ever asked the judge to make a specific finding that there was not a relationship? And the answer is no, I have never done that, but that may be one way to address it. If I guess Robert's going to make the point that if the domestic violence charge arises out of the contact between two parties and they're not married, could the judge make a finding that there was no relationship within the meaning and scope of the federal statute or the state statute? And would that cure the issue? And here comes Mark Kelly from the ATF.
Well, there's a tie in here on innocent until proven guilty, which is the law. But we're talking about, there's like two issues. It's like, is somebody going to be criminally prosecuted for being convicted of crime, criminal domestic violence, when they get back to play with assault and battery? That was, that's the courts decide. But what you've got on NICS background check, usually when the question comes up, is like, the NICS doesn't go by innocent until proven guilty. You're guilty until you prove you're innocent. So you get denied on NICS background check because you have an arrest or CDV, and then you pled to simple assault. NICS is going to look at the police report to see if it has a domestic element in it, and then they're going to deny you. But you can appeal it to NICS, and if you can clearly show that there was a finding that it wasn't domestic, it wasn't a domestic partner, it was a bar fight, then they'll overturn your NICS denial, and they'll give you a proceed the next time you try to buy a firearm. So I was just like, it's like two separate things. It is NICS background checks, or is it a future prosecution of you being a prohibited person in possession of a firearm, which is never going to happen federally. ATF doesn't pursue cases like that, except in rare instances where they're trying to do something beyond just a guy having a CDE conviction possessing a gun. Sometimes we had some bad case law in Virginia from an FBI case involving a strong purchase of a guy that had a CDE conviction and he got his nephew, and it may have been that Hayes case. He got his nephew to buy him a gun, and the FBI was trying to make a point with the case, and they created some really ugly case law based on that concept. And I just wanted to put that out there, but when you're talking about NICS cases or criminal prosecution.
Okay.
NICS will look at the police report, and then you have to appeal it and say, no, it wasn't domestic.
Yeah, well, I think we were more in the theory, but thank you, Mark. Speaking about Hayes, that decision basically was repeated in two other cases since then. The 2014 case of Castleman, which was unanimous, that was a Tennessee case. And in that case, I think they were talking about whether, well, how about if we're not going to say whether or not that he didn't violate, it wasn't some domestic violence, but was it intentional, was it only reckless? The statute he was convicted of had as an element recklessness. And they decided, yeah, whether you do it intentionally or whether you do it recklessly, it's still, once they had Hayes, everybody was in agreement. And again, that was another case that wasn't really clear what they called it. It doesn't have to be called domestic violence to be a misdemeanor crime of domestic violence within the meaning and scope of the federal statute. So that's the point. And 2016 was a 6-2 case. Again, a strong majority of the Supreme Court upholding that we don't care what it's called language if it involves the harm or threat of harm to an intimate partner or former intimate partner or child thereof, it's domestic violence within the statute. So be aware of that if you start pleading things. Somebody asked me a question in a previous seminar. How about if they null pros the charge, and instead of doing like a lesser included, somebody writes a new ticket and for something else. And I said, well, I don't know, we haven't had that case yet. That's how we know what the law is. When, we think we know what the law is when the General Assembly or Congress passes the law, but then when we read it, we think we know what it means, but we don't really know what it means until the Supreme Court or some court of appeal tells us, here's what it means, because they're always telling us new things and finding things in those laws that we didn't really see before. Oh yeah, I see how they got that. I didn't think of that. Okay, but we all know that. The duration, and here's where we get a little creative in South Carolina. The duration of the federal firearms prohibition is for life. If you've been convicted of a misdemeanor crime of domestic violence, or any of the other things, it's a lifetime ban. But South Carolina says if it was the 10-year felony version of domestic violence, the ban is for 10 years under state law. Okay, well, the federal ban's for life. What's the point? It says it's a ban for 3 years if it's the misdemeanor 3-year domestic violence version. And the judge made certain findings at the time. Or the 90-day version, 3 years. So now here's an interesting point. The General Assembly added Section 1625-30C. A person must not be considered to have been convicted of domestic violence for purposes of this section. I guess that's 1625-30. Unless the person was represented by counsel in the case, or knowingly and intelligently waived the right to counsel in the case, and those would be arguably challenges to the federal statute. And in the case of a prosecution for an offense described in this section for which a person was entitled to a jury trial, the case was tried or he knowingly and intelligently waived the trial by plea or otherwise. Likewise, a person must not be considered to have been convicted of domestic violence if the conviction has been expunged, set aside, or is an offense for which the person was pardoned. So, you all know, if you're convicted of a first offense misdemeanor in this state, or something that could have been handled in magistrate's court or municipal court, and it was a first offense, and there were no subsequent convictions in the next 3 years, I know, you're eligible to have that charge expunged like it wasn't there. Except in the case of domestic violence, it's 5 years. Same law, 5 years. So if you get that expunged, well, then both for federal and state purposes that you no longer have that conviction, you're no longer subject to that disability. Now, expungements, or expunctions as they call them in other venues, are kind of funny. I've been around with this before with the NIC system. Am I coming up on my time?
Yeah, you want to bring that up at the second half?
All right, shall we stop and go to a commercial break and bring the next Mr. Holbrook up from he's the NRA counselor that's basically responsible for, one of the people responsible for getting Second Amendment to say what we know it always has said, that it's an individual right.